Right, good afternoon everybody. We want to save as much time as possible for Mr. Mossoff and for questions from folks in the audience, so let's get started. My name is Darryl Lim. I'm the director of the IP program, the IP Center here at John Marshall. I'm very pleased to welcome you. I'm of course also very pleased to welcome Professor Mossoff, who joins us from George Mason University, Antonin Scalia School of Law. Right? He's here to share his thoughts on oil states, a case which most, if not all of you have heard about. He's going to be talking about essentially why he disagrees with the oil states holding, and it really takes the courage of one's convictions to go and talk about a disagreement, and so from the start that there's going to be a clash of views and it's going to be an interesting discussion. John Marshall has always been very proud of producing practice-ready lawyers, but also supporting real cutting-edge and interesting scholarship. So we're very pleased to welcome a scholar like Professor Mossoff to join us. And I'm also very pleased to announce the launch of an IP Scholars Roundtable this fall, so stay tuned for more details. We hope to bring more professors and scholars like Professor Mossoff here to John Marshall. A few quick announcements. April 10th, for students out there, we have our IP Town Hall. It's an opportunity for students to come and meet the IP Center, people who work there, faculty, to learn more about the opportunities that they have to participate and get access to the newsmakers in the IP world. We have Ted Essex, former administrative law judge at the ITC, coming to conduct a day-long seminar here at John Marshall in May. If you are going to be at Inter in May as well, please join us. We are having an alumni and friends reception in Boston. In June, we are having our annual ethics seminar that focuses on IP. It's really quite a unique seminar, I'm told. Not too many schools or indeed conferences focus on ethics in IP. So if you need ethics credits, it's our 10th year that we're doing this, and it's always an interesting program. Finally, 63rd Annual IP Conference, November 1st. Be there or be square. Students are at the center of what we do, and so for each of our special speakers, we always like to get students involved, and today I'm very pleased to have two students, June Cheng and Jack Scanlon, to introduce Professor Mossoff, but just also a quick acknowledgement to Jeanette Jia, who is helping with the AV, and you might have met Dan Krelovec at the entrance as you were coming in. So we very much appreciate students participating in what we do, and without further ado, June and Jack.
Ladies and gentlemen, thank you so much for coming to hear our esteemed guest lecturer, Professor Adam Mossoff. My name is Jun Cheng. Beside me is one of my colleagues,
Jack Scanlon.
We both had the pleasure of studying the exciting world of intellectual property with Professor Lin, and are honored to introduce Professor Mossoff, who had a fascinating presentation about the recent development in patent law.
Patent is a very powerful right. It is an exclusive right granted by the government to one or more inventors, allowing them to exclude others from making, using, and selling that invention. But is a patent a private property right, or is it a public right? When the validity of a patent is in dispute at an administrative agency, is a patent protected by the 7th Amendment? We are excited to have Professor Adam Mossoff here today to discuss these issues.
A little bit about Professor Mossoff. Professor Mossoff received a bachelor's degree in philosophy from the University of Michigan and a master's degree in philosophy from Columbia University. He graduated with honors from the University of Chicago Law School, where he received the Braddock Government Fellowship. Following law school, Professor Mossoff was a John Olin Fellow in Law at Northwestern University School of Law, and clerks for Honorable Jackie Weiner Jr. of the U.S. Court of Appeal for the Fifth Circuit. Then Professor Mossoff taught at Michigan State University, College of Law, University of San Diego School of Law, and Washington and Lee University School of Law. He is currently a professor of law, a founder and executive director of the Center for the Protection of Intellectual Property and at Antonin Scalia Law School and George Mason University.
In addition to this distinguished career, Professor Mossoff has also published numerous books and law review articles. His academic research has been cited by the Supreme Court, the Court of Appeals for the Federal Circuit, by federal agencies. Notably, the dissent in Oil States versus Greene's Energy cited his article, Reevaluating the Patent Privilege in the Historical Context. Professor Mossoff has been invited to testify several times before the Senate, the House, on proposed patent legislation, and he has spoken at numerous congressional staff briefings and academic conferences, as well as at the U.S. Patent and Trademark Office, the Federal Trade Commission, Department of Justice, the National Academy of Science, the Smithsonian Museum. And his writings on patent law and policy have appeared in the New York Times, Forbes magazine, Investors Business Daily, The Hill, Political, and in many other media outlets.
Once again, on behalf of my classmates, Professor Lee, and the John Marshall Law School community, thank you so much for coming. Let's welcome Professor Mossoff.
Thank you very much for that very gracious introduction. I am chagrined. I usually just ask people, just introduce me as professor of law and embrace our interconnected world, and you can Google me for everything else. But I really am just very much pleased to be here today to speak to you about the Oil States decision from the U.S. Supreme Court almost a year ago from the time of this talk. And thank you to Professor Lin for the invitation to come and give this talk. So the status of patents as property rights has been a long-standing dispute in American law and policy, reaching back to the founding era. Judges and commentators, congresspersons, and even justices of the Supreme Court have grappled with these issues about whether patents are in fact monopoly grants by the state or they are actually private property rights on par with other types of property rights secured to people in our society and other types of assets, both tangible and intangible. Different justices have been on either sides of this equation. Justice Taney has been on the monopoly side, for instance, and Justice Story has been on the property side. And very prominent founders have grappled with these issues, including Thomas Jefferson and James Madison. And sometimes you find even this dispute in the exact same judicial opinion by the exact same justice. Kind of a good example of this is Chief Justice Taft's decision in 1923 in Crown Die and Tool Company versus Nye Tool and Machine Works. He spends the first half of the opinion talking about how patents are an exclusive right, providing the right to exclude, to effectively securing the common law rights of acquisition, use, and disposal, which cannot be effectively secured to people but for the patent. And then he shifts gears halfway through the opinion and says, but of course these are monopoly grants, and then spends the rest of the opinion talking about how patents are monopolies, and then we shouldn't look to property doctrine or property concepts to understand how we should apply and interpret patent doctrines today. And of course, this kind of long-standing venerable dispute in law and policy really came to a head last year in Oil States versus Greene's Energy, a blockbuster case at the intersection of constitutional law, administrative law, and patent law. It involved patents on fracking technology, and of course, once you say to someone a dispute involving patents on fracking technology was a blockbuster case involving questions of constitutional law and administrative law, people thought, oh, this is about mass torts and the pollution of our water, or this is about the danger of the technologies of fracking or something. No, it's about patents and a special agency at the patent office. And then they're saying, oh, okay, this is not interesting to us, but to us. To other people, but to patent lawyers and to people who care about these issues very much, it's a huge issue. And in fact, this was an issue that went beyond just patent law. Specialists in constitutional law and administrative law followed this case very, very closely as well. And this is just one of many cases that we're going to be seeing arising out of our patent system in the coming years. This is the third case that had been decided by the U.S. Supreme Court addressing issues arising from the operation of the Patent Trial and Appeal Board, the PTAB as it goes by the acronym, which was created by Congress in 2011 in the American Invents Act. Prior cases, the Quozo decision and the SAS Institute decision addressed kind of procedural questions. But this was the really first significant case because this addressed the legitimacy of the PTAB itself, whether the PTAB itself was a constitutional agency and operating within the requirements of the Constitution and effectively implementing the protection of patents within the administrative state and as legal rights in our system. And so for my talk today, I'm going to basically have 3 points that I'm going to be talking about. So first, I'll be talking about oil states, kind of the what, how, and why about this decision, what happened, and what came from it. Then I'll be framing oil states within U.S. patent law and constitutional law with respect to the legal status of patents as property rights. And then I'll be talking at the end, lastly, about kind of, well, where are we going from here? So specifically, what did oil states decide? And even more importantly, what did it not decide? Because there's actually, we are guaranteed from the oil states decision itself that there are going to be additional cases addressing the constitutionality of the PTAB. And so it's a very important fundamental question of actually where are we going, which is why the title of my talk, Wither Oil States, the future of patents as property rights. All right, so let's get started. Let's jump in. Oil states, the what, why, and how. All right, so as I mentioned, this was a constitutional challenge to the PTAB. As I said, the PTAB was an administrative tribunal that was created by Congress in the American Invents Act of 2011. The sole purpose is to review and to cancel mistakenly issued patents by the Patent Office. So that's its sole function. And so its job is not to intercede during the patent prosecution process, but instead to cancel issued patents that were mistakenly issued, that do not meet the patentability requirements of the patent statutes. And so this is what raised the question presented to the court, because patents are property rights by statute and longstanding judicial decisions in this country reaching back to the 1790s. And the question that was presented to the court, in which it granted cert, was, is this a violation of the 7th Amendment rights of patent owners to have their property rights reviewed and ultimately canceled without access to a trial by jury in an Article III court? In a split decision, Justice Thomas writing for the majority and Justice Gorsuch writing for the dissent, Justice Thomas held that it was not a violation of the 7th Amendment rights of patent owners and that the PTAB was, at least with respect to the issue of the separation of powers in the 7th Amendment, a constitutional administrative tribunal. But interestingly enough, he didn't really reach the 7th Amendment question. He didn't have to, because he actually resolved the issue on a more fundamental legal distinction that has long existed as well within Anglo-American law. There's a distinction between private rights versus public rights. This is a distinction that reaches back to the English common law, which itself adopted from the Roman law. This is a long-standing distinction between types of legal rights and the status, the protection of those rights under the government. In oil states, Justice Thomas held that patents were, in fact, public rights, and therefore they were not entitled to the full scope of constitutional protections provided by the separation of powers doctrine in the 7th Amendment. So what is the public right versus private right distinction? I can only give a brief sketch of it. It is, by the 21st century, it is a very muddled doctrine and has become very confused. So I'm just going to kind of give you the basic foundational aspects of it. And if you have further questions about this distinction, I'm happy to address those in the question and answer period. Essentially, in basic terms, the difference between a public right versus a private right is the difference between kind of a privilege grant from the government versus a classic legal right secured to individuals in either property, contract, or even tort. So kind of examples of public rights, long-standing examples reaching back to the 19th century, are bridge monopoly grants, toll roads, and utility franchises. These are legal rights that have their existence solely by a special statute or regulatory grant conferred by either Article 1 Congress or by power conferred upon the executive in Article 2 to grant this as well. As you can see, therefore, what makes these public rights is that they're issued by the political branches, and the classic adage applies, therefore, what the government giveth, the government can take it away. You have no special claim, legal, moral, or otherwise, to this. In other words, these types of entitlements that are secured to people are left to the discretionary decision-making processes of the political branches, the executive branch and its administrative agencies, or Congress, if they choose to withdraw it as well. This is distinguished against private rights. As I mentioned, private rights are kind of your classic individual rights to bodily integrity, to property, to life. Classic private law doctrines of property, tort, and contract reflect these types of rights that we talk about within this distinction. These are the rights that, of course, that the Due Process Clause, the Fifth Amendment, refers to. You have the right to due process for the rights of life, liberty, and property. These are the rights that are secured by the Takings Clause of the Fifth Amendment. Nor shall private property be taken for public use without just compensation. And these are the classic rights that receive the full panoply of constitutional protections through things like the Separation of Powers Doctrine, the Seventh Amendment, and other types of constitutional protections. So this gives you at least a hint, therefore, in my framing of this kind of classic foundational conceptual distinction between two different categories of rights within our political and constitutional order, why this distinction matters. Because you might say, this is a nice distinction, that's a nice formalism. Yes, Justice Scalia, the namesake of your law school, liked formalistic conceptual distinctions. Why should we care about this? Well, because it's not just a formalistic distinction for the sake of formalism, because to define a legal right as either a public right or a private right dictates what type of protections that right receives under the Constitution. If it's a private right, it receives the full panoply of constitutional protections that are normally accorded to individual rights, and for which governments are framed, and in which we secure government, in which governments are created to secure. If it's a public right, this is your privilege, your monopoly grant. This is what the government is given to you as a matter of discretionary a discretionary grant, and therefore you don't have a particular claim to it, a particular rightful claim to it, and as a result, the government can do with it wishes. It can condition it on certain actions or inactions. It can withdraw it from you when it wishes, and this is long-standing constitutional doctrine going back to all the 1830s and earlier. Very famous decision, Charles River Bridge, where Chief Justice Taney denied a bridge owner the protections of both due process and takings claims because it was a bridge monopoly franchise grant. And he invoked the classic principle, what the government giveth, the government can take it away. So I just want to emphasize again, this is just kind of a sketch of kind of what the foundation of the doctrine. As I mentioned, as a constitutional doctrine, it's become very muddled today. You have lots of complaints from commentators and even the Supreme Court justices themselves that decisions are no longer sensical and meaningful, and they mixed protections for constitutional protections for public and private rights in the past 30 or 40 years. But at core essence, that is the distinction, and that is the distinction as it played a role in oil states, And thus you see, when Justice Thomas concluded that patents are a public right, then what he was saying is that therefore the question presented, do patent owners have a constitutional claim to go to an Article 3 court to have their property right adjudicated with respect to its validity? And do they have a right, therefore, under the Seventh Amendment to a jury trial, is inapplicable. And in fact, he didn't even, as I mentioned, he didn't even reach that issue. He spent one paragraph on the actual question that they granted cert on at the very end of the opinion, saying, we don't need to reach the Seventh Amendment question. For those of you who may remember constitutional law, the Seventh Amendment requires a two-pronged inquiry. Was this a right that was that received a jury trial in 1790 when the Bill of Rights was enacted? If it wasn't a right that existed in 1790, then you move to the second prong, which is it a right analogous to a right that was protected by jury trial in 1790? So it's a classic kind of historical two-step test. under the Constitution, that test is nowhere to be found in oil states because the entire question was resolved by deciding that patents are public rights, and therefore you don't even receive the protections of either the separation of powers or the Seventh Amendment, at least with respect to the question of patent validity. Now, this is very significant because this is the very first time since the very first Patent Act was enacted in 1790, the Supreme Court explicitly held that patents are public rights. They applied this distinction to patents in this context and concluded that they are public rights, even in the context of patent validity. The Supreme Court has never expressly held that before. And so this was a very significant decision, and it has tremendous implications for the patent system, and also has tremendous implications going forward for administrative law more generally, and in constitutional law as well. So that's oil states and the public-private right distinction in a nutshell. So what about this decision? As I mentioned, it's the very first time the court held that the status of patents as a legal right, as a property right, is a public right. And almost the entirety of his justification for that is captured in about one paragraph very early in the opinion, where he says patents are creatures of statute, and they are not found at common law, therefore they are classic public rights. Now this argument provided too little justification to reach that conclusion, and it also proved too much on the flip side. Now what do I mean by being too little justification? Well, today one often finds the distinction between public rights versus private rights to be conflated with a distinction between statutes versus common law rights. So rights created via statutory enactments, either of Congress or a state legislature, versus kind of classic so-called common law rights to your property rights in your land, for instance, or your contract rights adjudicated by courts that we study in our 1L courses when we start our law school careers. Right? And these two distinctions, and the reason for this is because they do map onto each other. The distinction between statutes versus common law rights does map onto roughly the distinction between public rights versus private rights, because as I mentioned earlier, a public right is something that's conferred by the political branches. And how would Congress confer a right? It has to enact a statute. It can't do anything else to confer a right. And the executive doesn't have any power to create rights, so it's going to only create rights if there's also a statute authorizing the executive to create rights. So Congress passes an organic statute, such as the Securities Exchange Act or the Federal Communications Act, which authorizes the executive to create an agency and to adopt regulations it's congruent with the congressional plan expressed in the statute. But they're not the same thing. They're not the same thing. And in fact, early courts, if you look at their opinions, they use the distinction between statutes and judge-made common law rights as largely just as a heuristic in understanding how to get at this distinction. They never said that they were necessarily the same. And the reason why they're not the same, why they don't map onto each other perfectly, statutes are always public rights, common law rights are always judge-made, common law rights are always private rights. The reason why is because there is no such thing as pure common law judge-made rights. There aren't any. In any of the kind of the classic private law doctrines, contracts, torts, and property, or in statutory doctrines like patent law. They're mixed, and they have to be by necessity. And this is very important because we do talk about our common law system and rights at common law, but we know that this is using common law in a very generic, generalized sense, and not in a true technical sense. We learned this in our property class, when we first learned property in our 1L year, right? Because what starts the modern fee simple, as we understand it today? Does anyone remember from first year property, or am I bringing back post-traumatic stress syndrome? I teach this, so I love it and I live it, right? So it's why I love it and I teach it, right? But if you recall, that what starts our modern property system in land is a statute enacted by Parliament in 1290 called the Statute of Quae Emptoris. And what did that statute do? It created and secured the right of the free alienation of property rights and land, moving us slowly and shifting us from the feudal system to a more free market system where people could trade the rights between them. This is what also starts the classic common law rule, later, famously enunciated by, Lord Coke in the 17th century that restraints and alienation are odious to the fee, right? That you cannot have restraints and alienation. That starts with the Statute of Quem-Torres, and in fact, to this very day, that so-called common law rule is in fact codified in state statutes across the United States as a foundational doctrine in property law, real estate, our classic private right. Right? But it's not just the Statute of Quem-Torres. Even before that was enacted by Parliament in 1290, they adopted the Statute of Gloucester in 1278, which creates the waste doctrine between life tenants, owners of life estates, and the follow-on remainderment. I know I'm really bringing back very bad memories now for some of you, right? And then you have the Statute of De Donis Conditionabilis in 1285, creating the fee tail, which the United States eliminated when we broke from England. And then there was a Statute of Uses in 1535, which put an end to the innovative work of lawyers creating all sorts of different estates. And Parliament said you can't do this anymore, and this is what set in stone for now to eternity the menu of estates that we now have, especially future interests. That's why we only have now remainder interest and executory interest, because this comes from the Statute of Uses of 1535, and of course the Statute of the 10 Years of Abolition Act of 1660, which eliminated feudal services that were associated with the fee simple, and so on and so on. And this codification of statutes that are not declaratory acts. These are remedial statutory acts. These are creating rights. Continues up through into the United States. A classic example that you also study your first year property right is adverse possession, which starts to evolve through the equity courts. But then the legislature stepped in and codified the various elements that are required for proving adverse possession, which is a positive remedy. It's a right that someone receives. It's where you get a forced transfer of a property right and land from the title owner to someone who was originally a trespasser and was later a squatter. And in fact, all property rights in land, I don't know how many of you remember this or may be aware of this, go back to a patent grant. Every title in land is traceable through its chain of title to a patent, because patents are the legal device by which the government first creates the legal right that's enforceable in court and protected through the various legal and political institutions we have in our country. A classic example of this that many of you are aware of, if not from law school, but just from growing up and learning U.S. history, is the Homestead Act, which authorized issuing patent grants in 180 acres to people who went out and staked claims to property and land in the Midwest and in the West. And if you read the Homestead Acts, which I've done, starting in the 1860s, they actually have a lot of similarities to the U.S. Patent Act, because these were not just outright grants, these were conditional grants. These actually provided for conditions that the claimants had to meet. In fact, you had to meet it for 5 years. So when you staked your first claim, you did not own the property outright. You had to then work the land for 5 years, and you were not allowed to alienate the property in any way, shape, or form. And if you failed to do so, you lost your claim to the property. And after 5 years, you would submit an affidavit supported by other affidavits that you had been working the land for 5 years, and the Homestead Act authorized the issuance of a patent to the claimant in fee simple. And there was extensive amount of litigation over this, of course, because what they were trying to do was they were trying to have people settle the land and work the land and convert it into something of value, as opposed to people engaging in money-making schemes and locking it up in investment purposes. And so there was extensive litigation over these issues. And the patents were being issued by the Patent Office, and the Patent Commissioner's reports in the 19th century contain statements of issuances of titles and land. And these cases were repeatedly litigated in Article III courts. And the position was consistent that you could not go back to the Patent Office to have a patent that had issued to someone under the Homestead Acts, canceled or reviewed or revoked by the Patent Office, that it had to be done in an Article III courts. So even with respect to property rights and land, your classic private right? Your classic example. There's nothing like private property rights and land. This is our reference point for understanding property rights more generally. These are not truly quote, judge-made or common law rights. You have an interplay, obviously, between the institutions of the judiciary and the legislature in both creating and securing these rights to the claimants to the assets. You have the same, by the way, the same pattern existed in patent law. The exact same pattern existed in patent law. You often hear it said by judges and scholars, patent law begins with the Statute of Monopolies enacted by Parliament in 1623. It's true. Modern patent law begins with that. Where they say you can get a patent to an inventor for 14 years, removing patents from being solely tools of economic and domestic economic growth by the Crown. But the disclosure requirement that we now take as core to our modern patent system, the quid pro quo of the patent system, you disclose your patent in exchange for your invention. Publicly in exchange for the patent right. And if you don't effectively disclose it, your patent will be invalid. You will search in vain in the Statute of Monopolies for that requirement. That requirement was created by common law judges in the 18th century. And it was then transported and adopted into the United States by American judges and ultimately by the Congress in 1790. But it's not just the disclosure requirement that originally started as a common law doctrine that was later, as a declaratory act, codified by legislatures and Congress. But to this day, we continue to have numerous judge-made doctrines in patent law. Doctrine of equivalence, that's not in the patent statute, right? Exhaustion Doctrine. We've had now 2 significant cases on exhaustion doctrine in the past 10 years, Quanta and Lexmark from 2 years ago. That's not in the patent statute. It's codified in the Copyright Act, but it's not codified in the patent statute. Experimental use defense, both under 102, as a defense against the public disclosure and public use of your invention, as well as a defense by a defendant against an assertion of patent infringement under Section 271. That's entirely a judge-made doctrine. It is not in the patent statutes. I could go on at length about this. Statutory bar. At least originally under the first to invent system, since now we moved to a first to file system, so everything is now statutory bar. That was created by Justice Story in Penick v. Dialogue, later codified by Congress in 1832 and then adopted thereafter in all the patent acts starting in 1836. Secondary infringement doctrine was a long-standing judge-made doctrine in patent law and was not codified until the 1952 Patent Act, which added sections 271B and 271C to our patent statutes. Non-obviousness doctrine, another great classic example, right, of a judge-made doctrine for which we got in 1952 Section 103. And one of the functions of Section 103 actually was to abrogate the flash of creative genius test, which was a judge-made doctrine created by the Supreme Court in the 1930s, right? That made it almost impossible to have any patent be valid. In fact, Justice Jackson famously said in a dissent in 1948, the only good patent is one that this court has not yet got its hands on. That's a situation that we probably could say today about patentable eligibility doctrine under 101. And in fact, patent eligibility doctrine. Talk about a judge-made doctrine that has come back roaring with 4 decisions from the Supreme Court in a span of 3 or 4 years, and of which Congress is now considering, just like with Section 103, a statutory amendment to the Patent Act to abrogate some aspects of those decisions. In fact, I just heard Senator Tillis talk about this yesterday at a patent conference, and if anyone's interested, I'd be happy to talk about that in the Q&A. By the way, as an aside, one often hears from patent scholars today, and sometimes from patent lawyers, that, well, okay, I get it, this public right versus private right doesn't map on perfectly to the statutory versus common law right point, but it's still significant that the Patent and Copyright Clause, which authorizes Congress to enact the patent statutes, is a discretionary clause. There's nothing in the Constitution which mandates that Congress pass laws that protect patents as property rights. And therefore, they're not on the same status as long-standing property rights and land like your fee simple. Again, this can't be right because it proves too much. It's a result of just looking at the Patent and Copyright Clause, Section 8, Clause 8, Article 1, Section 8, Clause 8, in isolation from the rest of Article 1, Section 8. Article 1, Section 8 is the grant of enumerated powers to Congress. Remember, under our federal system, only powers that the federal government has are those that are expressly granted to it as powers. And all of those powers are discretionary. You will search in vain for any of the clauses in Article 1, Section 8, mandating that Congress do anything. And by the way, what are some of those powers? Well, the power to create and maintain an army and a navy. Well, you know, it was fundamental to the founders who were steeped in natural rights philosophy that the primary moral justification for creating a government in the first place was to have a police and an army and a navy, right? Because that was what protected your individual rights. And yet you would be a strange paradox to say, yeah, but they actually thought it was possible that Congress wouldn't create a military to protect the American citizens' rights, right? What about the power that's conferred upon Congress to create the legal rules for how people can become citizens? Sure, yes, not mandatory. We don't need to have any more citizens in the United States after 1787. No, I mean, obviously, Congress is going to create these rules. Even more importantly, in Article 1, Section 8, is the power to create trial and appellate courts, separate from the Supreme Court. So the only court that is mandated by this Constitution is that there is supposed to be a Supreme Court. Every other federal court in this entire country is a discretionary institution. Again, what was one of the fundamental moral justifications to the founders for having a government was to protect your rights within military and police and to resolve disputes through the courts, right? These aren't mandatory powers. The powers are not mandatory. The powers conferred upon the federal government through Enumerated Powers Doctrine are discretionary. Of course they're discretionary, but that doesn't mean that they were not going to be implemented or were not thought that they would immediately be implemented. Limits are mandatory, of course. The Bill of Rights is mandatory because those are limits on the powers of the government, right? Limits are mandatory, but powers are inherently discretionary. That's what makes them powers and not limits. So it's about, as I said, it's an argument that proves too much, that you find this in Article 1, Section 8, Clause 8. And in fact, as evidence of the importance of this clause, it was one of the very first pieces of legislation that the first Congress enacted in 1790, was the Copyright Act and the Patent Act of 1790. Right? This was a time when Congress spent weeks debating about how they were going to refer to the president. Should we call President Washington His Excellency, His Highness, Mr. President? They spent weeks debating this, but they immediately enacted the Patent Act of 1790 and the Copyright Act of 1790 because they understood that this was fundamental to the growth of our country and to our burgeoning, at that time, innovation economy. So Justice Thomas's argument, you know, when he says, the core of his argument at Wales Days, patent rights are creatures of statute not found in common law. It's not enough. You could have a stronger argument, but that is not the core justification of what he provides. The rest of the opinion is him spending time citing cases and discussing the case law that either contradicts that claim or allegedly supports it. And I would highlight for your attention an article written by Richard Epstein that he published in the Federal Society Review, where he meticulously goes through the cases cited and quoted by Justice Thomas in support of his decision. And he shows at great length how significant passages, even in quotes, are elided from the quotes in the opinion, which significantly changes the meaning of the propositions for which they're being quoted for. But on the other hand, also, Justice Thomas's argument proves too much, right? As I mentioned, Oil States is the first decision that the Supreme Court says patents are public rights, and this is a very striking decision, given the fundamental status of this fundamental distinction in American law, constitutional law, in even reaching back to early English law as well. You find this distinction in Blackstone's commentaries, and even in Lord Cook's treatises, and going further back than that. And in fact, there's extensive evidence in the American patent law jurisprudence to the contrary. And as I mentioned, there were tremendous disputes about this issue, but there's also extensive evidence in the case law and in the jurisprudence that indicated that patents were actually thought of primarily as private rights. Specifically as civil rights in property. Civil rights because they were statutory. This is what was referred to by the classic legal term of art, privileges, as used in the context of privileges and immunities in Article 4 of the Constitution, or privileges or immunities as used in the 14th Amendment. This was a legal term of art that captured natural rights, which were immunities, and civil rights, which were privileges. This is why we refer to, for instance, the privilege against self-incrimination under the Bill of Rights. They don't mean there that this is a special grant from the government that you don't have to incriminate yourself. That's a civil right, because there are no courts in the state of nature. It only comes into existence once you have a civil government, but it is fundamental, it's on the same status, and is justified by the same natural rights that justify the creation of the government in the first place. And so in doctrine and concepts, in institutional development, and in rhetoric, patents were protected as private rights. From the get-go, patents were referred to as being title deeds, as securing to inventors their property interest in their new invention creation. Infringement was identified as being a species of trespass. And conveyances were secured and identified through classic common law property doctrines of assignments and licenses. A lot of people today think assignments and licenses are contract doctrines. They're actually not. They are common law property concepts for conveyances of property interests. In fact, you know this because the very first time you all learn the concept of an assignment is when you study leaseholds. And you learn for the very first time that when you transfer, if you're a tenant, you transfer your interest to a third party, that's not always a sublease. If you transfer your entire interest, that's an assignment. The concept is broader than leaseholds. It's the transfer of any entire interest. If you convey your property right outright, that is an assignment. The transfer of a non-property interest in a mere privilege in the context of a special grant in this context is a license. A mere license, as the language is sometimes used. So these concepts were explicitly adopted, as I've shown in my historical scholarship, from common law cases. Justice Story, in one case, even invokes in a patent law case the phrase, the enfeoffment of livery of season. For those of you may remember that from your first year property course, that was before title deeds, and that was, people would have the clod of dirt and the bundle of sticks, and that's how they would transfer Blackacre from one person to the next person in a ceremony in front of people, because you didn't have title deeds to record this, so that's how they would do a ceremony, and then they would beat some young boy so that he would remember it for the next 30 or 40 years. Thankfully, we don't do that anymore. The judges and justices invoke kind of classic common law property concepts as well. For instance, Justice Marshall, Chief Justice Marshall, Justice Bushwater Washington, and others would refer to the act of invention as creating an inchoate right, which is their term for a moral right, tantamount to something like first possession, that you then would perfect by securing legal title by suing for a patent. Similar to your first possession of land, perfecting by obtaining legal title at the county recorder's office or from the courthouse and getting a legal title instrument in what you first possessed. And they adopted from property doctrines as well procedural canons, like canons of construction. So that common law, there was a canon that you construed a title deed liberally in favor of the title owner if there were any defects or ambiguities in the title document, and the courts explicitly adopted that canon of construction for patents long before our examination system. So the presumption of validity starts not with the examination system of 1836, it starts actually before we have an examination system under the Patent Act of 1793, with the court saying these are title deeds, and applying to these title deeds the same canons of interpretation that they applied to title deeds in land. And as a result of this, courts in the 19th century often faced and recognized that patents were protected under the Constitution. In multiple cases, United States versus Burns, Supreme Court in 1870, Kammerer versus Newton, Supreme Court in 1876, and then in McKeever versus United States, Court of Claims in 1878, which received a summary affirmance by the Supreme Court a few years later, the Supreme Court repeatedly held that patents were protected under the Takings Clause as private property rights. As the Supreme Court says in U.S. v. Burns, the government cannot, after the patent is issued, make use of the improvement any more than a private individual without license of the inventor or making compensation to them. And in Kammerer v. Newton, the court says again that a patent owner can sue for compensation from a government official who uses his invention without authorization. Excuse me, I have to time myself, or I will go on forever, as a good professor would. So we have to impose external restraints on ourselves, just like a constitution. So they said, why? Because, quote, private property the Constitution provides shall not be taken for public use without just compensation. That was a patent case. So they're explicitly saying in the 19th century that patents were protected by the Takings Clause. And by the way, this was explicitly contrary to the English approach. So the English patent system, because patents were issued by the Crown, were deemed to be a privilege that was granted by the Crown retained what was known as the Crown's right, which was the privilege of using the invention without authorization from the inventor, because what the Crown giveth, the Crown can deem what it wants to do with it. And the U.S. courts constantly contrasted the U.S. approach with the English approach, saying, we are not England. These are not bequeathments from the Crown. This is discussed at length in the McKeever decision in 1878. These are property rights that are secured as such under the Constitution. And in fact, this is reflected in the fact of the very institutions that we created to issue and secure patents in this country. We applied concepts like the rule of law. So patents were not treated like administrative or discretionary entitlements that were issued by the executive. Disputes were resolved in courts. Legal courts, like all other legal rights, were just resolved. You didn't go before an agency or have to appeal to the executive. And they provided standard remedies that all private litigants would receive. We also created the Patent Office. Many people don't realize this is the very first agency, actually, as we would now understand an agency that was created by the federal government, was the Patent Office, that operated under the rule of law, that had rules for under the statutes for receiving patents and for examining them ultimately, and then for issuing them. And the administrative rulemaking that the Patent Commissioner often engaged in at the time was not left the discretion of just the Patent Office. An example of a right that was created by the Patent Commissioner was the reissue right. So the Patent Commissioner in the 18-teens realizes that sometimes patents have minor defects in them, stylistic defects that affect substantively the rights that are secured to them that are just by accident. So he created the ability of patent owners to come back to the Patent Office and have the patents reissued with the corrected defects removed, or with the defects removed and the patent corrected. We now call this the reissue right. You can go back to the Patent Office and have your patent reissued as well. This was, as I mentioned, created by the Patent Commissioner. It was ultimately challenged as not, because the patent statutes did not authorize the Patent Commissioner to do this. And in an 1832 decision, Grant v. Raymond, the Supreme Court affirmed the power of the Patent Commissioner to do this, to effectively secure to patent owners the full rights in their new inventions. This was not left to administrative discretion. It was immediately codified by Congress in 1836, adopting and continuing to apply classic norms of the rule of law, that we should not have pure administrative discretion to operate in this area, that this should be governed by the same norms and substantive rules and procedural rules that you have elsewhere, especially in other private areas of law. And then last but not least, of course, in rhetoric, patent infringement from the very early on was referred to as piracy. I've read all 1,400 reported patent law decisions from the 19th century in the Federal Cases Reporter, and I provided one of those classic law review footnotes. The footnote is a page long on a string site of all of the decisions from the Supreme Court justices and lower court judges using piracy and related type of rhetoric to refer to patent infringement from the very early 19th century and onward. Now, I want to emphasize again, the historical record is not one-sided, right? There was active disputes about this. Jefferson was Thomas Jefferson, writer of the Declaration of Independence, was a patent skeptic himself at times. And there were Supreme Court justices who were also viewed patents through a monopoly lens. Chief Justice Taney, an example, was one of them. There was always and has been an active policy and legal debate in this country about the status of patents as property rights. This is true of all areas of law. There's been active disputes in real property. There have been active disputes in contracts about what are the nature of these rights, right? And the pendulum has swung back and forth within patent law itself at times, between being very kind of strong, protective of patent owners, and then courts stepping back and being more protective and receptive to concerns about public domain and the public interest. And of course, even judges have had their own views. But this is why we distinguish between majority rule doctrines and minority rule doctrines, right? If you look at the general tenor of the institutions that we created and the majority of the doctrines that they instantiated and how these doctrines were applied, the legal regime created by Congress and implemented by the courts was not one of executive privilege and discretionary policy making to pursue economic policy goals, which is exactly how you would have had framed bridge monopolies, toll roads, utility franchises, and other types of grants. It was a private law system at core and in essence. It's securing private property rights. And again, the Constitution itself provides evidence for this. Because where is the power to secure patents provided for? In Article 1, in Congress. If we had followed the British practice of viewing these as privilege grants from the government, as personal privileges conferred by the Crown, we would have placed this as a power in Article 2 under the executive. They chose not to do that. They chose to put this in the branch of government responsible for enacting legislation to secure to people their private rights as civil rights that were not capable of being protected in the state of nature because they don't exist vis-a-vis government institutions that don't exist in the state of nature. So where does this historical survey and review kind of leave us? So what do we do going forward to kind of finish out my talk, and then I want to take questions and answers. Well, very significantly, oil states limited its holding only to the issue of the validity of the issued patent. So it said, yes, you may have a vested property right, you may have a patent that has been issued by the Patent Office, but they made a mistake under the statutory conditions 101, 102, 103, and 112 for receiving a valid patent right, and we can reassess that under those conditions. The Supreme Court, in the very last paragraph of its opinion, explicitly declined to reach either due process challenges under the Due Process Clause of the Fifth Amendment or the Takings Clause under the Fifth Amendment as well. And when the Supreme Court explicitly says, we are deciding only the question of patent validity as a public right, not these other issues under the Due Process Clause or the Takings Clause, that's what you call an engraved invitation from the Supreme Court to file a cert petition raising these issues. These cases will continue. These disputes and debates will continue. And now, this is why it's very significant. Because the court has already indicated that it's willing to consider intellectual property rights as cases of mixed rights, where they have features of both public rights and private rights. An example of this is B&B Hardware, which was decided 3 years before oil states. B&B Hardware was a trademark case and rising out of the PTAB, the PTAB equivalent for trademarks, where the Supreme Court, in its opinion, held that trademarks had characteristics of both public rights and characteristics of both private rights. And so it's still possible, it's still conceivable, the Supreme Court will, under a Takings Clause challenge or under a Due Process Clause challenge, find that patents are not public rights, but instead are private rights that still continue to receive the protections of other constitutional provisions beyond the Seventh Amendment and the Separation of Powers Doctrine. In fact, these cases already are occurring right now. Just 3 weeks ago, in Christie versus the United States, in the Court of Federal Claims, expressly relied on oil states and on its holding that patents are public rights to hold that patents are not protected under the Takings Clause. I'm fairly confident that a cert petition will follow, or appeal will go to the Federal Circuit, and then a cert petition to the Supreme Court. Now, Takings Doctrine is a harder road to hoe for patent owners, given the nature of Takings Doctrine and how it's evolved over the years. I've written on this as well. But the due process cases will continue as well. And this is where patent owners actually may have a much stronger claims. Because there have been a lot of things happening at the PTAB to which courts have been referring to with the euphemism of shenanigans. This is a phrase that some of you may have heard. The Supreme Court has used this in oral argument, and the Federal Circuit has used this as well, both in written decisions and in oral arguments themselves. These are issues, things that panel stacking has occurred at the PTAB. There's been the effective denial of the right to amend patent claims, which is actually expressly provided in the AIA before the PTAB. There have been serial petitions been filed, where people are really copying and pasting the content of the first petition or just filing again to harass patent owners. And there's been abusive petition filing solely for the purpose of harassing patent owners. So there's been cases where patent owners have been attempting to be extorted for money, saying if you don't pay us $10,000, we'll file a PTAB petition. And there are people who are filing PTAB petitions that have nothing to do with the patent system. So Kyle Bass, a hedge fund owner, very famously, who was paying attention to the invalidation rates that range anywhere from 60% to 98%, depending upon which review program you're in, has noted that this has an effect on the stock, and was still filing petitions and then was shorting stock in pharmaceutical companies. He doesn't care about patents, the validity of patents. He was just trying to make money for his hedge fund investors. So now these due process issues are being addressed currently by Director Iancu. For instance, he adopted the Phillips standard for claim construction as opposed to the broadest reasonable interpretation standard. He has done a notice of proposed rulemaking for the right to amend as well, and he's indicated that they also should start taking positions in addressing things like serial petitioning. But these are regulatory rule changes, and another director could just as easily undo these changes as Director Iancu is undoing the prior rule changes. And so the due process cases could still continue and could still have some bite. So regardless of the oil states holding that patents are public rights, there is going to be ongoing court challenges about these issues. We're going to continue to see this. The story is not yet finished on what is the status of patents as property rights within the United States. And we're going to learn, therefore, in the coming years, what is the actual extent of the oil states. Does oil states represent a reframing, fundamentally, of the status of patents as legal rights? Or is it merely going to be limited solely to the issue of patent validity as an issue of both something that is determined under patent examination for patent applications, and then after the patent issues for continued review by officers at the patent office? So thank you. So very happy to take questions next. Okay. Are you going to moderate the Q&A? Or?
I will indeed.
Okay, awesome.
Unless you want to wear two hats.
I can wear two hats.
One moment. So, just want to start by saying thank you for that very wide-ranging and deep talk. It's hard to be both at the same time. Somebody mentioned to me at the start of this talk that he had not met you before, but have been a close follower of you on Twitter. So, on Twitter you've only got so many words, and this allows you to get the full treatment of Adam Mossoff. I also want to acknowledge Ken Adamo and Alice Martin, who are with us today. They are members of our advisory board, and we're pleased to have them serve on that board for the service of the school and students. Now, this is Q&A, but we're going to start with students' questions. They submitted questions to me ahead of time. I'll ask a couple, and then I know Kevin Noonan, who is here. Kevin is an adjunct, by the way, very pleased that he's here with us today as well. And Patent Docs is his moniker, so please check it out. Great resource for all things related to patent law.
I've also had the distinct pleasure of working with Kevin on various amicus briefs, so it's a real honor for you to be here and to have gotten with you. Thank you.
Indeed. All right, so first question from student is about patent trolls. Now, would all states help combat the problem of patent trolls? Now, you obviously disagree with all states for many reasons. Is there any redeeming value in all states? And I suppose one of the possible redeeming values from this student's point of view is perhaps it might be useful in combating patent trolls. So what's your response to that?
That's a great question. And by the way, I would I like you mentioned my Twitter account earlier, because I also do on this day in innovation history, certain patent issued, and today is actually the anniversary of Thomas Edison receiving his patent for his improvement inventions to the telephone in 1883. So he actually improved the diaphragm and the electronic recording mechanisms for the undulating current. And in fact, that technology becomes adopted widely throughout all telephones after that. So it's an auspicious anniversary because it's one of we have about 1,000 of those anniversaries for Thomas Edison every year. So given how prolific inventor he was, but it's also relevant to your question because Edison would have been thought to have been a patent troll. And in fact, I wrote an article many years ago called "Thomas Edison was a Patent Troll." Because I am not a fan of that label. In fact, Director Iancu in testifying before Congress just last week reiterated his view as well that this is it's unhelpful rhetoric. It's a term that has not been easily or even well defined. And yes, there are bad actors within the patent system. That's, there are bad actors in every legal system. There are people who abuse contract rights. There are people who abuse property rights. And I love teaching those cases and and I tell my students, here's the case, the old man with the pipe chasing the kids down the street, stay off my land, right? We have people who abuse rights all the time. And unfortunately, the patent troll term and really an epithet it painted with a broad brush because it essentially came to represent anyone who did not manufacture a patent invention, anyone who engaged in licensing and had to sometimes sue people as a way to be paid a license for the use of their invention. And that's why Thomas Edison would have been a patent troll, because he licensed his patent inventions. And he sold his patents. In fact, that's why General Electric ended up in a patent war with Westinghouse over the AC alternating current versus direct current electrical systems, because General Electric bought their patents from Edison on direct current, and Westinghouse bought the alternating current patents from Tesla. Tesla would have been someone else who would have been accused of being a patent troll. His business model was explicitly patent, promote, and sell. And what that meant was come up with an invention and patent it, promote the patent, and then sell the patent. He never manufactured anything. He lived by selling and licensing his patent rights. And that's why Westinghouse and General Electric end up in one of the many patent wars that I think Tom Cotter talked about in an earlier talk in an IP lecture. Now, I was on the Hill.
Which is, by the way, available on YouTube for those of you who missed it. as well Adam's talk.
Yes, excellent. Very good job pushing your word. Excellent. The excellent remarks by other speakers. So I'm not a fan of this term because it swept within its condemnatory rhetoric individual inventors, startups, universities. Darrell Issa famously referred to universities as patent trolls because universities don't manufacture, they license their technology, and they sue people. Wharf got a multi-million-dollar judgment against Apple for patent infringement, and Wharf was accused. Wharf is the patent licensing, the technology transfer office for the University of Wisconsin, and Wharf was accused of being a patent troll in that case. And so I don't like that term. And it's it proved to be an unhelpful piece of lobbying rhetoric and in the policy debate, and it fed a moral panic about the patent system that really swept Washington D.C. for the past 10 years. And now, are there bad actors in the patent system? Yes. I mean, MPHJ, which was the entity that was sending out the misleading demand letters to the mom and pop coffee shops for use of Wi-Fi and things of that sort, the classic examples, yes. And they have been effectively dealt with in many respects through changes, through many of the court decisions in the past 10 years involving, for instance, making it easier to award attorney's fees, making it, and other types of changes. In fact, MPHJ was sanctioned by the Federal Trade Commission for its deceptive letters itself, so the FTC actually has authority to go after these people and has gone after these people. And also, courts always had their kind of classic, common law powers to control and manage their dockets to address these people. Courts have always had the power to issue sanctions, to dismiss complaints that are improperly filed, and they do this, and they continue to do this. And so the tools exist to deal with the individual bad actors. You didn't need to create an entire agency whose sole purpose was to cancel issued patents. I understand that what was caught up with the patent troll rhetoric, in a sense, was that these people are exploiting invalid patents. The MPHJ's patent is an example of that. But what you ended up creating was an agency that got captured by its mission. And in fact, when one federal judge famously said that the PTAB had become a death squad for patents, the then chief judge of the PTAB was asked about that statement, to which he responded, "If we were not being a death squad, we would not be doing what the AIA told us to do." And this has become a real serious problem because patents have become devalued as a result of this. The PTAB has created a cloud on the title of patents, and when you talk to particularly undercapitalized innovators, so universities, individuals, and startups, they have a really hard time obtaining venture capital financing now, because the moment their patent becomes successful, people will file petitions at the patent office, multiple petitions at times, to invalidate them, undermining the ability to recoup their investments, the commercial investments in the marketplace through their use of their property right.
All right, so would it be fair for me to characterize your view on oil states as they were completely wrong?
Fundamentally, yes. Yes.
It's fundamentally like underscore. Yes. All right. Now let's talk about.
Because I actually think there was an interesting question of, under the 7th Amendment, how that should have come out. And it would have been interesting to see it reach it. There was actually kind of a very vibrant historical debate about whether patents were protected by the Privy Council, which was the prerogative court under the Crown in England in the 18th century, or they were protected in the common law courts, and how this translated over to the United States in starting in 1790. But they didn't have to they didn't reach that issue at all. They didn't really fundamentally reach that. They talked about those issues a little bit in the opinion, but the fundamental decision was these are public rights, and we don't even need to reach these kind of fundamental questions about the application of the Bill of Rights because they don't apply in this context.
So this is a great segue actually to the next question, which kind of deals with this issue of American exceptionalism. So is the U.S. alone in the way it's approached the revocation of patents? Are there other countries that do the same?
So we have...
Because
actually,
one of the things, just to say, about American Invents Act is this attempt to kind of harmonize with the rest of the world. And yet in doing so, the question is, have we created an entity that makes us an outlier compared to the rest of the world?
Yes and no. So to find some historical context, the U.S. has historically had a unique patent system insofar as we've taken seriously the fundamental proposition of protecting patents as property rights. And economic historians and other historians, Zarina Khan is one, for example, who looked at this, have identified this in a comparative context. So looking at the United States vis-a-vis coming out of England, the United States relative to other countries in the early 19th century and up to late 19th century, compared to Germany and France and other countries. We took very seriously the idea of what it means to secure these as property rights. And in fact, one of the significant features of that was that it created what Zarina Khan called the democratization of invention in the United States, that you didn't have in other countries. Because all property rights should be accessible to all people. Right? It's the Homestead Act. Anyone could go out there and stake their claim, right? And then, in 5 years, file your affidavit and receive your fee simple. And we took seriously that proposition. So unlike England, we had very low filing fees at the U.S. Patent Office. We made it very easy to review patents that had issued at the Patent Office, comparatively speaking, because these things were written in hand. I've read a lot of these, very hard to read. Talking about notice failure, trying to read by hand these documents written in hand. And as I said, we protected them under set rules at the Patent Office itself, and we adjudicated them through disputes before the courts under set rules. We were fairly unique in this approach, and as I said, many economists, Zarina Khan and Neil Amaro and Steve Haber and others have also identified that this played a key role in a lot of the successes of the U.S. innovation economy starting in the 19th century. Not the only role, but it was a factor. That stable and effective and robust property right protections in every area of our economy, whether intangible assets or intangible assets, are a foundation for economic activity and economic growth. And in fact, we had a very robust secondary market in patents and licensing and in selling of patents in the 19th century. There were called patent agents at that time. These would now be the patent trolls, the people who are buying and selling patents and are licensing them. And this was a byproduct of patents being protected as property rights. Because once you say that these are property rights and you can assign them and license them, because a personal privilege from the Crown can't be transferred to someone else. It's personal to you. It's why James Watt had to partner with Bolton, because James Watt got the patent on the steam engine, but then he couldn't transfer it to anyone else, and he was an academic researcher. He wasn't a business person. So he partnered with Bolton, who was the actual industrialist, to actually manufacture their steam engines. In the United States, Morse, who was, for those who know, Samuel Morse, who invents the telegraph, he's a professor of art at NYU. And he wanted to be a business person, so he transferred his patent rights to third parties. who then created the electromagnetic telegraph, the American Telegraph Company, and proceeded to license and manufacture telegraph lines. And this is the key to actually a successful economy. This is what Adam Smith identified in The Wealth of Nations, right? Specialization, division of labor. The fact that we all are lawyers, right? And someone else is a doctor, and someone else is a business person, and someone else is a police officer. This is what leads to efficiencies in the economy and creates more value for everyone else. And this is what protecting patents as property rights helped us to do in this country. And this was unique. This was part of America. This was part of American exceptionalism. Is that phrase that term is used? We have, since then, embraced more openly harmonization with the rest of the world. Why we shifted to first to file in the American Invents Act, that was explicitly done on harmonization grounds. Again, we were unique. We protected the first to invent, not the first to file until 2013. And the justification for the PTAB actually was that we will do something similar to what, for instance, Germany has. And that's why I said yes and no. Because Germany actually has a very effective and runs very well an administrative process for review of issued patents on their validity issues. And they don't have the problems we have now. And I can tell you, in 2011, during the debates over the American Invents Act, people were pointing to Germany's administrative review system as kind of the model. And of course, being Americans, we didn't create the German model, we created some American monstrosity that has not functioned the way that it needed to function. And part of that was because they were really working under kind of a nirvana fallacy. I mean, they didn't impose any substantive or procedural restraints or limitations on the PTAB when they created it. And it was under the assumption that this agency would be put into place and it would function perfectly and it would work great, with no problems, no capture, no concerns, because that's how every government agency works, right? That's how the DMV works, and so we are much less unique now than we used to be. We have harmonized with the rest of the world, but in doing so, we've actually created, I think, more problems because we've mashed together our unique features with other features from the world instead of just going wholly with one system or staying with our own.
All right. Now, quick follow-up question, and then I'll open to the audience, so we've got enough time to take a bunch of questions. Mm-hmm. Now, so would your answer then, as a follow-up question, be that we should look to the German system as the model to adopt in place of what we have now, and would that then resolve your concerns over how all states turn out?
Not necessarily. Because the German system is also kind of it's nested within a very different legal framework in the legal system. The German system is a civil law system, and it exists within a very kind of different kind of ethos as well with respect to their country. So I don't ideally I think we should. If you ask me, I think the PTAB should be eliminated, and if they want to kind of have some type of legitimate review, they can, right? There are Article 1 courts that are not invalid. The ITC is an Article 1 court. The Court of Federal Claims is an Article 1 court. What makes these legitimate courts? Because they function like courts, right? These are adversarial processes, but they have due process. They follow set procedures. The substantive and procedural rights of the litigants that appear before them are respected, and you have full review and appellate rights. You don't get, there's no Chevron deference for the ITC or the Court of Federal Claims on appealing an adverse decision, as there shouldn't be. If you want a full administrative review in an Article 1 agency, Article 1 court, then create that and do that. You can do that, and we've been very effective in doing that in this country. And it's not impossible to do that in the patent system. And I think that's the better approach to take to do this, to address these types of concerns.
Okay, I have one more question, but I'm going to save that question so that Kevin can finally jump in before.
Well, actually,
hold on. Name and affiliation, please.
Kevin in the VHB here in Chicago. So I'm actually happy to go on because I'm overcoming the trauma of going back to first-year property. Although I did hear from Claude Carr, from Professor Carr, who's a great teacher, and it made a little bit less painful work than other ones. But we take someone with your erudition, and I'm flattered that you were honored that I talked about it.
Okay, so you can explain to me now the difference between fee simple and fee tail?
Yeah, later.
Come on, do it.
But details are probably not that as I call it. But anyway, given your argument about the 19th century, the federal government gave, and you mentioned the Homestead Act, gave land, real property to people as part of the company. Was there any parallel if the government said they made a mistake, that they would take it back?
Yeah, oh no, these cases were litigated, there were a lot of cases.
Will you repeat the question?
I apologize, yes, I promised I would repeat the question and I did.
It's been hijacked now, just sit there and relax.
No.
Kevin asked the very good question of, under the Homestead Acts, where the federal government was granting land through patent grants, were there any cases where the government said we made a mistake and we want to take it back? Excuse me. There were no cases where you had a self-initiated action by a government agent itself. But you had litigated cases where someone said, you lied in your affidavit. You were really sitting on this property for investment purposes. You weren't tilling the soil and you weren't raising cows and doing the things that we want the homesteaders to do in homesteading land. And people tried to petition the Patent Office to revoke the initial grant. And in these cases were taken into court, and the courts repeatedly and consistently said, you cannot go to the Patent Office to have the grant revoked. Once the grant issues, it's vested. It's a vested property right. It's no longer inchoate, and as a result of that, it has to be adjudicated in an Article III court. And in fact, in the late 19th century, there are some significant patent cases where the question is raised about whether a patent can be revoked by the Patent Office. This is not even unique to the PTAB. And the Supreme Court cites to these Homestead Act cases as precedent for saying, no, the Patent Office does not have the authority to revoke a patent once it's been issued. And once it's issued, it's a vested property right.
Hey, hold on. Name and affiliation.
No, wait, come on. We're rocking and rolling here now. We were quiet.
Hold on, Ken. Come on, set a good example. Name and affiliation,
I'm sorry.
please.
Go ahead.
And then you can go. You can rock and roll after that.
Ken Adamo, Kirkland knows. Weren't there cases, though, even though you're saying private individual couldn't challenge the maintenance of the grant or the impropriety or alleged impropriety of the grant because they weren't following the working requirement, which is interesting because this country has always hated the fact that half of the rest of the world requires, if you're going to hang on to your patent, that you got to work it, but that's for a different day. But couldn't the I seem to recall there are cases where the United States government could move to take the patent out.
Yes, so there were, yes. So the question was, were there cases where the United States government moved to revoke patent rights? Yes, and that was and no one knows how to pronounce properly the Latin phrase. Greg, you probably know it better than I since you've been studying this in depth for several years now.
I mean, Sire Ferris
action, which comes from, which was originally the power of the Crown to step in to revoke legal entitlements. And that right continued up through the United States. In fact, the Sire Ferris action played a role in litigation over Alexander Graham Bell's patent due to some lobbying efforts. In fact, this is lobbying efforts by defendants who were trying to get Bell's patent revoked. So they lobbied the Attorney General to bring a Sire Ferris action to invalidate Bell's patent, which failed. So this did exist, and it did happen, and people were able to petition at times and succeed. But that's different than it did exist at times. There's no set rules for this. That hasn't. I don't remember the last time the Sire Ferris action has been invoked in this country. Greg, again.
I think there were some remnants of it in like the 1860s.
1860s,
more like inequitable conduct and stuff.
Yes, it's now captured more in things like inequitable conduct and competition law concerns that has been replaced by those types of things. But yeah, I mean that actually did exist, and it was provided for in some of the early patent statutes. And Christopher Beecham is a historian who's done some great work. I highly recommend his book on Alexander Graham Bell's patent, where he details some of these issues. And then of course he did some issues on some original petitions before some courts to invalidate patents. under the 1793 patent system, where we didn't have an examination system, and they provided for people to invalidate issued patents in that context.
But the comment about this coming up in the early days of inequitable conduct is accurate.
Yeah.
That's in the 1920s, 30s, and 40s.
Yes,
I remember reading all that once inequitable conduct turned into the flavor of the
inequitable conduct is another judge-made doctrine that has that has played a very significant role in the patent system in the modern era. But Ken's point too about how other countries had working requirements and the United States did not is another example of how the United States took seriously the concept of a property right in securing a title to first to invent, as distinguished from the rest of the world. The reason why you had working requirements in the rest of the world, and started originally in England, was because patents were originally tools of the government for domestic economic growth. And so you were incentivizing people to engage in economic activity by incentivizing foreigners and to come and bring technologies from other countries into your country and to work them and to create a home-based trade in that area. And that's why you had a working requirement. In the United States, we said, well, these are property rights, and property rights can be used in all sorts of different contexts. They can be used for investment purposes. They can be used for licensing. They can be used for other things. Landlords don't live and, quote, work on their land when they lease it to tenants, and therefore owners of property rights in new inventions shouldn't be required to work their inventions either. They should be protected in the same way that all other property right owners are protected in how they choose to deploy their invention. Because the progress of the useful arts is very much achieved through the disclosure function, where the issued patent is published and is reviewable in the patent office by any follow-on inventors, and through the licensing practices of the innovators. So Charles Goodyear, for instance, for those who don't know, he had nothing to do with Goodyear Tire and Rubber Company. The company was created 40 years after he died. In fact, it led to a trademark dispute with his heirs. Charles Goodyear was just your classic example of an insane, crazy inventor who just loved rubber. He wrote a 2,000-page treatise about the history of rubber, where hundreds of pages of it is just him listing all the cool things you can do with rubber. You can make life vests out of it, and umbrellas, and coats, and shoes. Yeah, but what he engaged in was a significant amount of licensing and assignment of his property rights to business persons, because he didn't want to engage in business, just like Samuel Morse. He wanted to continue to investigate and explore all the awesome features that make rubber rubber.
Okay, we have a question from the back. Name and affiliation.
Yeah, Jeff Dixon, Saigon Law, this is PC.
Mm-hmm.
Very simple question.
Yeah.
How do you spell Sciaferis? I was just trying to Google it just now.
SCIRE, and then new word FARIAS.
Okay, then I see two hands in front.
That's not a simple question, by the way.
Thank you. Rich Beam Patent Law Firm. Professor Mossoff, thank you for speaking and elucidating the subject. I noticed in reviewing the opinion that you're cited a couple of times, so congratulations on that. Justice Thomas, of course, is one of the foremost experts in the land on patent law, not always acting favorably to patent rights. I was not surprised by the result of this opinion for three reasons. One is there's a statute before the court, and I think courts try to preserve statutes when they can. Secondly, they're arguing about the government giveth, therefore the government can take it away. And lastly, again referring to Justice Thomas, there doesn't seem to be any love for patents in the Supreme Court or any love for jury issues. But what I want to thank you for is helping us to understand the other side that's not really addressed in the opinion in favor of private property rights. And what I wonder is, well, just one other observation, and then I'll get to my question. And I share your concern about the PTAB and its propensity to invalidate patents and the abrogation of rights of patent owners. That said, I don't think we've seen too much yet what happens when a patent makes it through the PTAB and is preserved, and that knocks out a leg that the challenger has to stand on. And I think we're going to see more of that. But my question is this. You're arousing some discomfort on my part, seeing how the courts can abrogate private property rights. I've had the impression in reading this opinion that property rights and patents would continue in the same way that they have in trade, assuming that they survive the challenges in the PTAB. And so my question really is in the nature of a so what. Where could oral states lead that might, and you've shown some positive ways in terms of the division that you can have both aspects of public rights and private rights. Where do you see that oral rights might be used to further harm patents in business and in trade?
So, a really good question, the evolving great question. A really good question is where do we see some of the impact of decisions like oil states on kind of patents as commercial assets, as they're being used by inventors to obtain financing and to go out into the market and to trade with them and to create products and services. Is that a fair summary of the question? It's a great question because that is the fundamental reason, right, why most people spend the thousands of dollars to get a patent is because they want to ultimately engage in commercial transactions with it or used in a commercial context, right? So there's defensive patenting, which is a commercial context use, non-use, but it's commercial as well. And decisions like oil states, the problem with oil states keys into what I referred to earlier as and characterized as kind of a moral panic about the patent system that has kind of swept through Washington, D.C. in the past 10 years. That was kind of represented by the patent troll rhetoric, the phrase the patent system is broken, and so what you have is kind of constant proposed legislation, what was called the Innovation Act and the Troll Act and other pieces of legislation that continue to restrict and in some cases outright eliminate patent rights. You've had a slew of decisions from the U.S. Supreme Court over the past 10 to 12 years where, as you mentioned in your question, and you're exactly right, that the dominant line is a restriction in the cases outright elimination of patent rights, limiting patent rights, and then you have regulatory actions. An emboldened, more aggressive Federal Trade Commission. Going after settlements in the biopharmaceutical context and going after patent licensing, currently in the action against Qualcomm. And so the problem is that this has created a general, as what I referred to earlier, as a cloud on the title. It has destabilized patents as vehicles for investment and deployment in the marketplace. It's very often, I know it's conventional wisdom that patents are a reward to the inventor for the act of invention. Yes, that's certainly the case. And I like to always frame it as patents are what secure the fruits of the inventive labors of the inventors, is the rhetoric I prefer to use. But like all property rights, and as a property, and patents are a property right, they serve also a very important function of commercializing that invention going forward from there. Because if your concern was just rewarding inventors, we wouldn't have a patent system. We would have a prize system or some other reward system. We explicitly rejected those systems because we wanted to create a system, as the economic historians have shown, like Serena Kahn, Steve Haber, and others, that we wanted to create a system that would promote and drive an innovation economy, promote commercial growth. And to do that, you need stable property rights. You need property rights that people, that investors can trust to invest in, that won't be eliminated or revoked tomorrow. Imagine if you were trying to sell your house. This is how I sometimes talk with staffers and other people in DC about this. Imagine you're trying to sell your house. And you're saying, all right, you're talking to someone who's willing to give you hundreds of thousands or perhaps millions of dollars for your house. But that person also knows that tomorrow, anyone in the world can file a petition at an agency to eliminate the title that you just transferred to them. And not just one petition. 50 petitions can be filed. And they can be filed for anyone, for any reason. Someone doesn't like you. A former enemy from high school has decided to track you down and have his revenge, right? Which, and this is not far-fetched. These are some of the things that are happening. And so what you're hearing now from venture capitalists, and Bob Taylor, the head of the National Association of Venture Capital, he testified for Congress and saying, we are finding it more and more difficult as venture capitalists to rely upon patents as something by which we make investment decisions in startups. Now you might say, well, they don't do that, and it's actually false. Just several years ago, Deepak Hedda and several other economists showed a causal link, not a correlation, but a causal link, because he was a Thomas Edison fellow at the patent office, and he got access to thousands of patent applications. He was able to prove, as an economic matter, that having a patent more than doubles your chance of receiving venture capital funding. And I heard one economist refer to this as the holy grail of the economic analysis of the patent system. This is something that people have been talking about for years, and venture capitalists have been saying as a matter of anecdote, like we rely on patents, and they self-report when in survey studies, we rely on patents. It varies from industry to industry and from technology to technology, but they do, that we look to patents as investment decisions, make investment decisions. Professor Hedda and his colleagues actually proved that patents more than double your chance of receiving venture capital funding as a startup. And then he and his colleagues carried out the implications of that even further with their study. Because if you're able to get venture capital funding, then you're able to hire more employees. You're able to start create the supply chain necessary to produce and commercially distribute your product in the marketplace. And therefore, as a startup, you're able to get through the valley of death, as is known to venture capitalists, successfully and become a small or medium enterprise in the innovation economy. And therefore, they not just more than doubles your chance of getting venture capital funding as a startup, but that actually having a patent causally is linked to your success as a small, medium enterprise, as a new company in the economy, producing and selling or licensing in the economy to create new products for consumers. And when you create institutions where you have tremendous rule of law concerns, you have tremendous due process concerns, you have tremendous concerns about arbitrary decision-making actions, you are creating a cloud on the nature and ability of property rights to serve the function that they do economically in an economy. And this is just true for tangible property rights just as much as it is for intangible. So Hernando de Soto, a very famous economist who identified that property rights, having clear title, having clear rules for transferring property rights, and having kind of stable property rights are key for developing economies. He recognized that this is just as true for patents. And this is what's been eliminated currently in our current situation by institutions like the PTAB. And this was the policy concern that was driving oil states. That policy concern was not the job of the Supreme Court to address. The Supreme Court should not be engaging in policy making. In fact, that's one of the criticisms of the Supreme Court through its patent eligibility decisions right now, is that it's engaging in de facto domestic industrial policy decision making. But it is kind of something that this case keys into. And the ongoing cases that the Supreme Court guaranteed in the oil states decision that will continue, the due process challenges, the takings clause challenges, and so on, will continue to create an era of instability and uncertainty that will leave it more difficult for people to create startups and to create new products and to get products into the marketplace. And this is very important also because we are not in a vacuum in the United States. So other countries, particularly China and Germany, are doing the exact opposite from what we're doing right now. And when you talk to venture capitalists, and I've now talked to a bunch of them, this is where I receive a lot of this information from, they tell me that when they talk with the new startups and new inventors now, and the inventor says, I have a patent, their response to that is, where is that patent? We're not interested if it's in a US patent anymore. We're interested, is it a German patent or a Chinese patent? Because you can get an injunction in China, you can get an injunction in Germany, and you can get the patents in China and Germany on AI and fintech and things of that sort that under the current patent eligibility rules you can't get in the United States at the moment.
Okay, I'm afraid I've got a call time here. We've got more questions that we've got time
I reject your arbitrary
I'm
rulemaking.
sure. No, it is publicized. It's not arbitrary. necessary at all. And you've got public notice right there. But I'm sure Professor Mossoff will be here. If you've got any questions, feel free to come up after this ends and direct questions. Now, you might be a Twitter star, but if you become a YouTube star, we're going to claim that you launched your career here. All right, please join me in thanking Professor Mossoff.